This video is directed to attorneys, but it is useful for clients as well. If you're considering suing a hospital, gathering evidence through employee interviews is crucial. But before diving in, it's important to understand the legal warnings, including those tied to the Upjohn case and the California Rules of Professional Conduct, Rule 4.2, to ensure the process is handled correctly. Let's break it down. First, who can you interview? Attending physicians are key. These doctors directly treated the patient and can provide insight into medical decisions, treatments, and potential errors. Their testimony helps determine if the standard of care was met or breached. Nurses are also vital witnesses. They're on the front lines, monitoring patients, administering medications, and documenting care. They can reveal details about what happened during a patient's stay, including any oversights or deviations from protocol. Support staff, like medical technicians or orderlies, can be interviewed too. They may have observed specific incidents or noticed issues with equipment or procedures that contributed to the problem. Hospital administrators are another group to consider. They can shed light on policies, staffing levels, or resource issues, like understaffing or inadequate training, that might have impacted care. If the lawsuit involves a specific department, like radiology or surgery, specialized staff such as radiologists or surgical assistants can provide details about diagnostic tests or operating room practices. But this is your wish list. In reality, you cannot interview most of these people as they are either parties or protected employees. You can depose them, but as you know, the hospital attorneys will create scripts that are very hard to get around. You need to follow the rules of professional conduct, or you can get booted off the case and sanctioned by the state bar. So let's address the Upjohn and California Rule 4.2 warnings. Under the Upjohn v. United States 1981 decision, communications between a company's employees and its attorneys may be protected by attorney-client privilege if they're made to provide legal advice. This means some hospital employees, especially administrators or those involved in internal investigations, may have privileged communications that can't be accessed without legal processes like depositions or subpoenas. Your attorney must navigate this carefully to avoid violating privilege. Additionally, the California Rules of Professional Conduct, Rule 4.2, prohibits attorneys from directly communicating with a party represented by counsel without permission. If a hospital employee is represented by the hospital's counsel, your attorney cannot contact them directly. This rule ensures ethical communication and avoids improper influence. Your attorney may need to coordinate through opposing counsel or use formal discovery methods to arrange interviews. Employees may also hesitate to speak due to fear of retaliation or confidentiality policies. Your attorney can use legal tools like depositions or subpoenas to ensure cooperation while protecting the process. The goal is to build a clear picture of what went wrong. By interviewing the right employees and respecting legal boundaries, you can uncover critical facts to strengthen your case. Always work with an experienced attorney to navigate these interviews, comply with Upjohn protections, and adhere to California Rule 4.2 ethical guidelines.
Daniel Horowitz is a trial veteran with over 200 jury trials to verdict. He assists and consults with attorneys who are expert in their field and takes private cases for clients as well. Call Daniel Horowitz at 925-283-1863. Again, our number is 925-283-1863. I hope this video was helpful.